So let me set the stage. What happened? That's a good question, figment of imagination. I see LA, my hometown, is in the house. Okay. Norm Eisen, Steve Vladeck, and Katie Phang, three contrarians coming at you this Friday afternoon in the latest Supreme Court bombshell opinion on the deportation cases. The court has decided, per curiam opinion, that means they decided as a whole, seven of them, that a decision of a district court and of the Fifth Circuit were wrong, and that we have to stay the deportation. Some of us call it the abduction of Venezuelan migrants to El Salvador. Steve, why don't you set the groundwork? Almost 2,000 of our contrarians have joined. Explain what the Supreme Court just did, and then we'll come to Katie for a reaction, and we'll just all chat about it. Steve.
Sure. So let me sort of take a half step back, right? So after the Supreme Court on April 7th had said that individuals who wanted to challenge their removals under the Alien Enemies Act had to go district by district, we had this district by district litigation where, Norm, as you know, and Katie, as you know, in each of the district courts other than the Northern District of Texas, the trial judges blocked, whether through a TRO or preliminary injunction, any removals under the statute. The Northern District of Texas was the outlier. Um, this led right to this remarkable Supreme Court ruling late Friday night, early Saturday morning on April 19th, when we had that NBC story about the buses literally on their way to the Abilene airport, where the justices very temporarily blocked further removals from the Northern District of Texas pending further order of the court. It was cryptic. It was late at night. It had no opinion. Norm, this is the opinion. And so, 4 weeks to the day of when the Supreme Court first blocked those removals, now we have the explanation as to why. And the explanation as to why is basically sort of twofold. One, because you know we think the Fifth Circuit, the Federal Appeals Court, does have the power at this juncture to review the detainee's challenge to both the lawfulness of the Alien Enemy Act invocation on its face and the amount of process that's due in each individual case. And Norm, two, and this is actually, I think, a massively important holding from the Supreme Court, and they should do it on a provisional class-wide basis. So even though Judge Hendricks, the district judge in Abilene, had rejected class certification on behalf of anyone in the Northern District last Friday, the Supreme Court saying, no, at least for purposes of where we are right now, we're recognizing a provisional class, meaning, right, this case can go forward on behalf of any detainees in that district. What's really striking, Norm, last thing I'll say, and then we should kick it to Katie, is the court then remands, right, not to Judge Hendricks, who they seem to be quite done with, but to the Fifth Circuit, right, and directs the Fifth Circuit to address as expeditiously as possible both the facial validity question and the due process question, so that then the Supreme Court can review this on the merits. And so this is basically, I mean, my sort of quick gut reaction, this is the Supreme Court saying, stop trying to manipulate the system, Trump administration, when it comes to the Alien Enemies Act. We're not going to let you remove anybody until the merits have been resolved and until someone has conclusively settled how much process is due. And that's a huge deal, at least in the context of Alien Enemies
Huge.
Act litigation. What it means beyond that, I think, is a harder question.
Katie, you and I were talking as we got ready about not only how striking that majority opinion is, but there's an Alito Thomas concurrence that is Kafkaesque that would have given no process at all under the circumstances, dressed up in technicalities. Talk about that alternative view and how lucky we are that that's not the majority.
Yeah, and I apologize because my connection's not great. So if
It's
you
good
guys are having
enough.
problems hearing me,
It's
let me
good
know.
enough. We can hear you.
So so across the board, nobody is surprised that Alito and Thomas dissented in this instance, but I think it's the Kavanaugh concurrence is the one that kind of made me fall out of my chair, and that he agreed that injunctive relief should be granted while there is a determination of how is this process going to happen. Steve totally nailed it when he said that this got kicked back to the Fifth Circuit norm so that we can finally have a process by which this can play out. It's the absence of a process which has created all of this drama. And so the fact that we will now have not only you have to do X, Y, and Z government, but then we also are going to have an acknowledgement of what constitutes notice. Notice is something that seems to be an incredibly subjective thing when it comes to Trump's ICE and Trump's government. Notice must be defined. And when we talk about notice, folks, we talk about how much is the reasonable amount of time that a detainee gets to be able to obtain a lawyer and challenge this and to achieve what due process means under the Constitution.
Steve, the court now, this is the, depending how you count, you're the expert in what is called the shadow docket. And friends, that's the not the normal Supreme Court docket like today. Uh, you have a proper briefing and a run up and a calendar and an argument. We had that today on Birthright. But this is the short term snap dispositions of things. Steve, I don't know how you count, but the administration has not had what you would call a winning streak on the shadow docket at the Supreme Court. I was struck today, but the court has been in these per curiam opinions. The court has taken a middle course. I read the opinion today as saying, for example, the court conceding that they may not be able to get back the 200 or so people who are in El Salvador now. So, would you talk about that opinion and how the court what the court said, but also how they utilize that to kind of judo flip the administration and get to this important due process ruling?
Yeah, so Norm, one of the things that I suspect you, Katie, and I all reacted to in reading this short majority unsigned opinion is how the majority justifies its intervention. And the intervention is justified by the very difficulties that have arisen in the Abrego Garcia case, where the majority points expressly to how hard it has been to get folks back from El Salvador, right, who were removed, whether wrongfully or not, as a reason to block removals now, right, as a reason for requiring real notice, real process. And Norm, this is the key. The court today is saying something it had not said before, and resolution of the underlying merits question of whether the proclamation is lawful in the first place before anyone else can be removed under the Alien Enemies Act. And listen, I don't want to overstate this. Like, I think one of the things that I think is tricky about just how many of these emergency rulings the Supreme Court's handing down, Norm, is I don't know that we can extrapolate from one set of rulings into the other. But at least in the deportation and removal context, this strikes me as the majority throwing their hands up and saying, "We're tired of this. We're tired of the game playing." There's one point where they take a shot at the district judge for saying that he was only given 40 some odd minutes when he really had 14 hours, right? And
Yeah.
so the opinion is spicier, Norm, than what I'm used to, which I think is, at least in the due process space, a good sign going forward.
It's not the black and white shadow docket. It's the shadow docket in Technicolor that we got with this per curiam, with this unsigned majority opinion today. Guys, if you trace through, though, if you look at how they decided the Dellinger case, where they refused to override the DC Circuit on a wrongful firing, then the big spending case, where the state AG said, hey, Congress did not authorize you to freeze spending. The Supreme Court would not get involved there. 9-0, and then 7-2 in the first two immigration cases. Um, uh, my case, which came to them out of the Ninth Circuit, where they did grant a stay, but they gave us a roadmap on the wrongful firings. We were back in court the next day. The next morning, we were in court. We followed the roadmap. We got the order. That order is still in place in a federal court, from a federal court in San Francisco. And now this additional immigration order, there is a through line. Then you have two statements by John Roberts' friends, two statements where he has said Trump, without naming Trump, he said it's too much. You know, he's defended judges, defended the rule of law. Katie, I was interested, apropos of what Steve said, by something else in the Kavanaugh concurrence, where Kavanaugh wants to get to the merits, because we saw that in the
Yeah.
birthright citizenship case today as well. I represent a coalition of 36 conservatives, and Katie and I, because Katie is both a commentator on the Contrarian and a co-litigates with me at Democracy Defenders. Steve, we have to get you to be the head of our appellate department. Um, we have this big conservative coalition we represent, and they say that the Alien Enemies Act is against conservative principles. And Katie, in Kavanaugh wanting to get at it, you almost felt in that Kavanaugh concurrence, you know, that he's chomping at the bit to put an end to this nonsense. What was your read, Katie?
Yeah, and it's at the end of the concurrence, guys. If people are going to go and check out this opinion, at the end of the Kavanaugh concurrence, he says, I would have preferred to get to the meat of the issue, brief it, and let's hear argument on the merits of the Alien Enemies Act invocation and whether it is a proper invocation. I would agree with Steve, Norm, that we need to be cautious about saying that one parallel can be drawn to the other. But I do think, in light of the split that we're seeing coming through, a few things are happening. You and I talked about this, Norm, yesterday morning on Coffee with the Contrarians. These judges are telling Trump, stay in your own lane. Your lane does not have to do with the judiciary. We're going to tell you what the roadmap is for you to do what you need to do. And I think this is a it's a taking back by the judiciary of its co-equal branch of government powers in this instance. They are saying you've gone rogue, and we're going to tell you how to get back on this track. I do think Kavanaugh wants the opportunity to be able to speak about the merits, but I do think it's proper to not hasten this. I think let this play out with the proper roadmap being provided by the Fifth Circuit before SCOTUS weighs in, because we don't have a roadmap, guys. We just have a lot of just willy-nilly bullshit action by the government. We don't have a roadmap. Let's see what due process is defined by the Fifth Circuit before Kavanaugh gets to weigh in on this.
And Steve, I'll do one last round with the two of you. Steve is writing his Substack post. Friends, I got to cross promote Steve and Katie, their official recommended contrarian Substacks. They are two of the best out there to explain to you what's going on. I'll write about this in my column for the Contrarian, my weekend column that we send to everybody, because it could have been so much worse coming out of the immunity opinion. Of course, my friends' views that I mustn't be overly sanguine based on the shadow docket, no matter how spicy today's opinion was. Of course, they're right. But it could have been so much worse when we rolled into this term, not knowing where the court would be. Would they let Trump run amok. If you want to know how bad it could be, and I swear we're going to close, look at the Alito Thomas dissent, where they not only condemn the people who are in this dark site prison, some mistakenly or contrary to court orders deported to El Salvador, but they say that this Kafka-esque sham that the majority condemns, not really providing process to people to say, hey, there's a court order saying you can't deport me, like with Abrego Garcia, or hey, I'm not a member of a gang, I'm a hairdresser with a tattoo. That kind of Kafkaesque sham, that's what the concurrence embraces. So, Steve, how can Alito and Thomas, feel free to disagree with my dystopian interpretation, but they really are crossing into darkness at noon territory here. What sense do you make? What is their jurisprudence? What is the vision of America that the two of them are purveying in that dissent?
I don't. I mean, I don't really know, Norm. I will say I wrote a post. Back. So Justice Alito had written a dissenting opinion the first time the court stepped in this case back in April, and I wrote a very long post taking apart what I called his misbegotten dissent in that case. If that was misbegotten, this is just I don't even know what this is. But what I will say about Alito's dissent, Norm, is it's actually remarkably useful because there are a couple of places where he makes clear that passages in the majority opinion that maybe were somewhat ambiguous actually are holdings and actually reflect the majority deciding something he disagrees with. So I actually think here's a case
Huh.
where Alito's anger got the best of him because he's basically saying, like, I can't believe that the majority has said we can have provisional class certification and then a preliminary injunction. Well, every district judge who wants to issue nationwide relief is now going to point to that passage and say the Supreme Court just said this was okay. Um, right? And
Even the
so
dissent.
that's right. Well, but the dissent confirms what that this is what the majority meant. And so, I don't know I've always been sort of frustrated by the inconsistent circumstances in which Justices Alito and Thomas are and are not procedural formalists. They have a remarkable tendency of being procedural formalists when it allows them to sort of rule against things that they don't want to necessarily uphold, but that they like politically. And they have a remarkable way of sort of brushing aside procedural
Just
formalism when it gets in their way.
explain to the people what a procedural formalist is.
So most of Alito's dissent is that the courts are basically powerless to do the things that the majority is doing here. And it's relying on a series of very technical arguments, several of which, Norm, I should say, are not even true. But even if they were true, right, they are basically saying it doesn't matter that the sky is falling, we have to follow the rules. Right? That would be a perfectly defensible worldview for a judge if they were remotely consistent. Alito and Thomas have a remarkable tendency to brush past comparable procedural concerns when they want to reach the merits.
Your wife is putting flattering messages in the chat,
I saw
Steve.
What does she
Karen
say?
was
I didn't
saying
see it.
go
She
blue.
likes your T-shirt.
She said go blue.
I told him leave the T-shirt on. Don't get dressed up for us. Katie, last word. We always like to end, no matter how grim the situation. But this is not a grim one. This is a ray of hope. We always like to leave the contrarians with a good word. Bring us home, Katie Phang.
So it's Friday, it's 5:27 Eastern, and we're having this conversation courtesy of the Contrarian with the brilliant Steve Vladeck and Norm Eisen. And the reason why we're having this conversation is something is happening, folks. The pressure is working. This would not be happening in a pressureless vacuum, guys. Meaning, all of the support that people are giving towards democracy is having a result. It doesn't make a difference if Alito and Thomas want to be subjectively picky about how they get to where they want to be, because that is the exemplary hypocrisy of the GOP these days. What we need to focus on is due process one. Due process still lives to fight another day. And that is my good news to end this Substack Live.
I love it. And remember, we filed those briefs on behalf of those conservatives with your help. The Contrarian's not owned by anybody, so all profits go to support the litigation that Katie and I do at Democracy Defenders Fund and our new appellate chief, Steve Vladeck, whether he wants the job or not. Okay, guys, have a great weekend. Wow, over 5,000 of you joined us on no notice whatsoever. How terrific is that? Have a great weekend. We'll be back, Coffee with the Contrarians, bright and early Monday morning. And look for my weekend column hitting your inboxes tomorrow about this and much more. Have a great weekend, Contrarians. Thanks, Steve. Thanks, Katie.
Thanks to you guys.
Bye, guys.